So I wanted to jump into a little bit of workers' compensation and just sort of talk about a few things as it relates to that. You know, we talk about the basics in terms of what rights you're entitled to having gotten hurt while in the course of your employment. You're entitled to medical treatment. You're entitled to temporary disability. You're entitled to receive an award at some point. But what's really and truly, I think what's been really great to know in terms of how it all plays out is that it's supposed to be, I mean, by the very title, workers' compensation. What we've seen more and more, it's become, workers' comp insurance company compensation. And the downside to what we're doing is that, again, not being able to be in court, not being able to have a judge really apply some pressure to a respondent's attorney to call an adjuster or get something done, and being able to sort of hide behind the computer screen is caused this delay, which is just to the advantage of the insurance companies. The workers' compensation system is designed to get people immediate benefits. But when you see the insurance companies sending people to doctors who aren't going to recommend treatment because they've been working for the insurance companies for years and years and years, now you're automatically fighting for things. This past week, I had a client who thought he worked for one company, but he actually worked for a different company. And that insurance company or that company then had insurance. So you call that insurance and they say, no, that particular employer is managed by this insurance company, which is a subset. And then no, there's a third party administrator. So you got to go to a third insurance company. And it's designed to basically make it as difficult as possible. And we've been banging away now for 5-6 weeks to try and find who the insurance company is. And the whole thing, I mean, just to give you a sense of it, the whole thing starts because the employer has failed to report the injury. So as a result of the employer failing to report the injury, you then have this wave of time that has now come and gone, again, to the advantage of the insurance company. So when I'm calling now 6 weeks later to report the claim, and I have some insurance adjuster saying, well, I don't have any information about any of this. And then you said, oh, here's a pay stub, here's a hospital record, here's the fact that we've been reaching out, so it becomes this delay that is just to the advantage of the insurance carrier. Now, eventually it's going to work out because we'll get the right insurance company, the client will get medical treatment, they will get their benefits. But again, it's this drawn out delay, which is counter to what workers' compensation is supposed to be, which is remedial social legislation, which is designed to prevent injured employees from suing their employer, and in exchange for that being granted immediate benefits. So some of the historical context of what this is all about gets sort of now lost in the shuffle. But again, going back to my little example here is that, and I've talked about it, is that the most important thing when you get injured is to make sure that you have reported the claim. And if the employer is unwilling to do so, either you contact the insurance company directly or you send a letter certified mail to the employer outlining exactly what you are trying to report, so that 4, 5, 6 weeks later, when an insurance adjuster says, well, I don't have any information about that, then all of a sudden you're going to be like, well, I do, and here you go. So that is some of the sort of context of workers' comp. The other side of the fence is that in terms of numbers of cases being put on any one given day, again, we're in court one day, we'll say, oh, just adjourn that, one cycle, which is 3 weeks, or 2 cycles, which is 6 weeks, whatever case so you say that while you're sitting there in court. And then the next thing you know, all of a sudden, bang, here we go. It's now 4 weeks or 5 weeks, and it's in the computer system. And you're like, well, wait a minute. When we were in front of the judge, this is what happens. And so now all of a sudden you got to. So now what's happening is we are going to a situation where you get ready for court, you go to court, then after court, you got to wait a few days to get the information into court. And then after that, now all of a sudden you got to go check to make sure what you said in court, it becomes an impossibility. There's no way to manage all of that. So this level of frustration gets attack. So you're getting a situation where now it becomes frustrating for a client because they're not receiving their benefits. No kidding. And it becomes frustrating for us because we're not able to put cases through, because then we're not able to, satisfy what our clients' expectations are. True. And this pressure, it's been this pressure, and not having things move is what causes that to happen. Now, on the good side of things, right, we've had a bunch of wins. I mean, even in the land of COVID, we've had a bunch of wins. I this past week actually got an appellate division, which is an appeals court, to reverse a decision by a pension board, so that a client of mine can now finally receive their disability pension benefits. So that happened on Monday. We had a bunch of cases actually take steps forward as a result of finally being able to get a judge to step in and require the insurance company to go get authority or to start a trial. So, and therein lies the issue, right? So we're starting with, okay, well, let's get authority. And the way it's supposed to work, again, is you conference a case. The other side is supposed to get authority. They come back. I got authority. Case settles. There you go. That took 3, 6, 9 weeks, but whatever, limited period of time. And then all of a sudden now it's like, well, the adjuster this and this happened, and I didn't get that done, and blah, blah, blah. And the next thing you know, it's like 6 months. So I have a case that's coming up on Monday. We've been waiting almost a year and a half for the attorney to get authority. And the attorney actually had the nerve to again write to the judge saying, yeah, I need some more time because the adjuster can't speak to the supervisor to get the authority. I said, you know what? Enough's enough. Here's what we're going to do. We're going to get a new exam, and we're going to pre-try the case, and we're going to have a judge make a decision. And this is a case that when a judge makes a decision, they're not going to like that. So good job, And the other part of it is Liberty is one of the worst, but forget that stupid bird, emu, or whatever the heck that is. Morning, Rella. But the point of the story is that, at the end of the day, for workers' compensation to really work, it's designed to move at a pace that gets to the resolution. And when this happens, and it's like anything else, right? You got a hose, right? And you clamp up one of the ends of the hose, and all of a sudden there's this big pressure that builds up behind it. Well, that's the exact same thing that's happening right now. And there's too much behind it, and there's not enough of the go for the system to crank out the way it's designed to do. I think there are some other interesting forces, because of the virtual nature of things. And I think one of a good example from a judiciary point of view is to describe workers' comp as sort of a coral reef, in the sense that both sides need to survive. So if one side, respondent or petitioner, gets too powerful, right, the other side's going to die, and then the whole reef dies, right? So the idea is to make sure that both sides are equally, a symbiosis, and making sure that everybody's working, and and the whole thing continues to work. So one of the interesting comments is that, well, at this point, what is, or where is some of this delay being built in, or why is there a delay built in? And, in my opinion, one of the interesting things is that now that everything is virtual for the last 2 years, or almost, now at this point, we're almost at 2 years, which is enough to just drive you out of your mind. But the idea is that, not driving to court. And I think that respondents' attorneys, when they were working and driving to court, they could bill for that time. And so there's a chunk of time that they're not able to bill for now. So now all of a sudden you get another reason why a case can't maybe settle one time, two times, because, well, you got to get a little extra juice out of the 3 times, 4 times, 5 times court appearances in order for the other side's lawyer to get what they need to get from their particular file, much to the chagrin and damage of the respondent's attorney. Now, that's Sam Gaylord's opinion. There's, I don't have any empirical data to suggest that that's true, other than 25 years of experience knowing how the other side works